Hi everybody, hello Bay Area. Welcome to another episode of Ask Me Anything. I'm Yaasha Sabba from Sky Unlimited Law, and we're going to answer your estate planning and asset protection questions. First question, how do I legally protect my property and my finances from my daughter and her husband and make my brother my heir? Wow, why would somebody want to do this? My husband died and the house went directly to me. We have a living daughter left, that's nice, but she and her husband have been contacting other parties behind my back and about purchasing my home. Okay, so it sounds like you're a little bit senior now and your daughter and husband are anticipating an inheritance and they're ready to make some money, so they want to start looking for people to sell the home, or they're thinking that they need to get you out of the home because you are no longer capable of taking care of the home yourself. Let's continue. They've been trying to bring doubt to my mental state and gain control of my assets, control of my estate through incompetence, which is completely false. Wow. I am a widow and low income, but not enough to be senile. I'm afraid of what measures they will do against my brother after my passing and what they may plot and plan to do while I'm still living. I'll let you guys know that I do have clients that are incapacitated, and we do have to use their children to help do estate planning, long-term care planning, advanced planning. But here, when I have someone writing a note to me, the question that you see in the description here, and it is well written, there's no typos, no nothing, and it's a nice, long, elaborate paragraph, that is not incapacity. So just the fact that you're writing a question to me and asking me this, I can tell you that, okay, I think we can judge that you're not incapacitated and your daughter and her husband are doing some funny business. So you want to exclude them from being able to get your home. You want to exclude them from your estate. You most certainly can do that. There are two ways. You can either write a will, and actually there's three ways. You can write a will and just say, my daughter doesn't get the home, or I disinherit my daughter. That means your daughter will get nothing from your estate. However, in order to do that, that means the will has to go to probate. And if your daughter is making arguments that you're incapacitated or you don't have mental capacity, then you better bet that she is also going to make the argument in court to a judge that when you wrote that will, there's no way you had the capacity to do that. And that is one way that wills get defeated, is when someone writes a will and whoever the beneficiaries or whoever is disinherited comes and says, oh, they couldn't have written that will. They didn't have the mental capacity to sign a contract like that, so they couldn't sign a will. So alternatively, a process that's a little more secure for you is to create a trust. You create a trust just like creating a will, but this time you're going to get it notarized, not just witnessed, and you're going to move the home into the trust. So all these moves, even though it seems so simple, the fact that you are notarizing a trust and you are actively signing a deed, notarizing the deed, recording the deed so that it actually gets into the trust, those are a lot more steps where you have to have capacity at each one of those steps. And it is harder to argue at each and every step that you didn't have capacity, okay? Especially if you go to an attorney who can help you create that trust. The attorney is actually going to be an advocate for you, saying, at the time of creating the trust, of course she had capacity. It was up to me to decide. And the law will protect your attorney and you in a lot stronger way. So if your daughter ever tries to contest the trust, one, trusts are harder to contest in court compared to a will because you are taking proactive steps. You're not just writing a document and letting that be it. You're writing a document, creating a trust, but you're also moving property into it. So you're doing a lot more steps than actually creating a will. This is why judges trust trusts more than they trust wills, because you take a lot more proactive steps to create a trust. It avoids probate. They're harder to contest in court. And at the same time, you can disinherit her daughter. Shame on her for taking advantage of you like that. This is not just your problem. This is a growing problem in the United States. We have a lot of children taking advantage of senior parents because they're desperate for money or they want money, and it's usually against the parents' wishes. And at the same time, we have a lot of children that are doing a phenomenal job using the same legal tools that kids use to take advantage of their parents. Other kids are using it to take care of their parents. And that's a good thing. And that's why we have these laws and these abilities for kids to kind of step in and take control little by little without sweeping the rug out from under you. But here, those laws can be abused. And that's why we have this growing problem of elder abuse. And so if you see this happening, and then for everyone else watching this AMA, if you see this happening, you need to make sure that somebody can advocate for the parents, whether it's protecting them from their own children or their own family members, which is usually the case with elder abuse, or just making sure that the parent has their wishes and voice heard. So reach out to an attorney. A lot of counties in the area, they even have advocates for this kind of stuff and social welfare and all that stuff. Elder abuse is a really bad thing. And I don't like what the daughter is doing. So I have no shame. If you need help disinheriting her, let's cut her out, okay? Next question. I'm looking to purchase property with my partner in the name of a trust to improve our privacy and create the framework for future estate planning. We're unmarried with no kids or other assets. Is it acceptable to have a joint living trust for an unmarried couple? Does this make sense to put our new property into the title of this trust? Absolutely, yes. The answer, all aboard, yes. You can create a trust with anybody you want. You don't have to be married to create a joint trust. Do I recommend that you create a joint trust? Not always. I think under very limited circumstances like this one, it's okay. In fact, you don't even need a joint revocable trust. There's actually something that's revocable and much simpler called a land trust. So if you ever want to protect your privacy, you can use a trust or a land trust to hold title to the real estate, name somebody else like your attorney as trustee, and boom, the property records doesn't have your name on it. So you are completely private. So whenever someone goes searching for real estate, like a personal injury lawyer or a private investigator, trying to see what you own, what assets you have, they won't be able to find you because when you originally purchased the property, it is the land trust that's purchasing the property, okay? So this is a good thing. And within the land trust, you can set the terms on when the property gets distributed, when the trustee sells the property or stuff like that. It's a blank canvas. You can write whatever you want. So that is actually a huge advantage to yourself for protecting privacy. Keep one thing in mind though. You're protecting your privacy. You are not protecting liability. A revocable trust is not an entity. It's not a company. It's not a limited liability shell. There's no such thing for revocable trust. So if there's a slip and fall on the property or anything goes wrong, you and your partner are personally liable because you both are the grantors and beneficiaries of the trust. So all you're doing by creating this trust is simply removing your name from the title and enhancing your privacy, which I still have a lot of clients that's what they do. If you want to add privacy, what I would do is instead of spending money on a trust, create an LLC and have the LLC purchase the property. You don't have to be listed as a member of the LLC depending on what state it's in, right? So in California, you might have to disclose the members. That's one hard part. But if you have someone else as the manager of the LLC, like your attorney, then that's the name that's on the LLC's records. And then your membership is kept private. And at the same time, the property is owned by the LLC, not by you. So you have privacy and limited liability protection. The downside with that is you have to pay franchise tax here in California. That's about $800 a year. So if you don't want to pay the taxes, if you don't want to deal with the administrative costs and all that of creating the LLC, then yes, a land trust is the way to go. If you guys are unmarried, if you guys are married, then yeah, absolutely. A joint revocable trust, take your name off the trust, name somebody else as the current trustee, and that's how that works. So privacy works in many ways. It gets a little complicated on how we can do this dance to keep your name off the records permanently. And if you have more questions, please reach out, send them our way.